following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the right to information and its related legislature. Is this philosophy being adequately utilized by the Sri Lankan populace? And with elections in discussion, how does the right to information factor in? A very good evening and thank you very much for taking the time to join us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, tonight's topic is something that affects every single one of us watching and every single citizen in Sri Lanka, specifically with the climate we're in relation to elections as well, and that's on the right to information and also the Right to Information Act in Sri Lanka. And to speak about this topic, we have someone that's very well versed in these matters, and that is Mr. Rajeev, Amarasuriya, attorney at law. So thank you very much for taking the time to actually come to our studios and explain this topic to us.
Thank you for the invitation. It's nice to be here.
All right, a little bit of an introduction into our very special guest here. He is, of course, the former secretary of the Bar Association of Sri Lanka. Mr. Amarasuriya is also a member of the governing board of the Central Bank of Sri Lanka, and more specifically to this topic, he's also the country representative for the Commonwealth Legal Education Association. So safe to say we're in good hands when discussing this topic. Next, before we go into the actual discussion, here's a little bit of a breakdown of how we're going to actually explain this entire vast area to you. First, we'll be talking about the basics and the fundamentals. What exactly is the right to information and its philosophy? Next, we'll be going into the current context in Sri Lanka. And finally, we'll be talking about future perspectives. All right, well, we have a lot to cover today, so let's get right into the discussion. Once again, sir, thank you very much. We have a lot to cover, but of course we have to go about it in a very orderly manner so that there's actual understanding and consensus about just how important this philosophy is in our context as well. So before we get into any of the specifics and the complicated areas, let's go into the basics. Could you please explain to us about the right to information in Sri Lanka and also the Right to Information Act and its fundamentals and how exactly it functions in Sri Lanka?
Yes, Anuradha, it's interesting. So in 2015, the fundamental right to information was introduced to the Constitution as Article 14A. So the Constitution sets out certain provisions and says these are the rights you have. And in terms of fundamental rights jurisdictions, it's the premier right the citizen is granted. It also says that the fundamental right to information would be in terms of law. So that is why in 2016, the Enabling Act came into operation. So the fundamental right is set out in the Constitution. The operation of that right, obviously any right is not unrestricted. There are limitations. Those limitations, operation, how does one set about it? What are the institutions which get caught up under the right to information regime? Information officers, what are the grounds upon which information can be restricted? All of that came in the 2016 piece of legislation. So that is how the body of law is now set out. Of course, thereafter we have judgments, orders from the Right to Information Commission and also now the Court of Appeal. So that is the jurisprudence we have in respect of right to information.
Right. So there are specific salient features of legislature that we have seen come about in relation to the protection of right to information and also the regulation. I believe that would entail the covering of certain public authorities as well.
Yes.
If you could specify and go into a little bit of detail in relating to what authorities are actually covered.
Yes. So if you go, let's just look at it in logical form. So if you go to the Right to Information Act under Section 3, subject to the provisions of Section 5, every citizen shall have a right of access to information which is in the possession, custody or control of a public authority. First and foremost, this information which we say we have a right under the Constitution must be information which is either in the possession, important words, custody or control of a public authority. So then the question arises, who are the public authorities? So that is also spelled out both in the Constitution and also in the enabling piece of legislation. So, of course, when you say public authority, there are certain institutions which come straight to mind. So that is covered, ministries, any body which is, any body office created under written law, government department, public corporations, so on and so forth. But in addition to what you and I would understand as being public authorities, there are a few other institutions which are also caught up. A private entity organization which is carrying out statutory or public function or service, a private entity, under a contract or partnership or agreement or a license from the government, offers to the extent of the activities covered under statutory public function. So it's interesting. So as much as we say public authority, it goes beyond into private entities which perform certain public roles, statutory public function under, say, an agreement or even a license. So the banks, for example, who are licensed by the central bank, there is material to say that the banks also now get captured under the Right to Information Act, of course, to do with the public function they perform. Then you have even a non-governmental organization that are substantially funded by the government or in department to gets caught up within this regime. Then you have again higher education institutions, including private universities and professional institutions, which are established, recognized, and licensed under any written law or funded wholly or partly by the state. So if you are an institution which comes within, of course, the general idea, traditional idea of what a public authority is, but in addition, if you come under a piece of legislation, the likelihood is that you get caught under the definition of public authority. So that is how it works. So if it is a public authority as deemed under this section, and of course a given interpretation and determined by maybe the commission or the court, or if the institution itself takes up that position, then the information which is in the possession and control of that authority then comes within the Right to Information Act. So that is how, to your question, that is how a public authority is covered under the provisions of the Act.
Exactly. And picking on what you just mentioned, yes, sir, in relation to the tertiary entities or third parties that we've seen, yes, for example, you said banks that may be connected to the Central Bank of Sri Lanka in some, yes, form, they also have some sort of responsibility to uphold in making certain pieces of information available, yes, to the public. Yes, yes. How exactly does that play out when it comes to specifics?
No,
how does that
it plays out like this, because if the whole concept is that if it is a public function or statutory function which the agency is doing. So there are functions which the government, state entities can. Then there are certain functions which are licensed out to public entities to perform, private entities to perform. So if it is in that ambit where, say, for example, either a bank, even a media institution, even someone who's under license is performing certain functions which come within the realm of those public functions, then of course you would fall under the provisions of the Right to Information Act. Of course, having said that, this is a 2016 piece of legislation. It is still finding its feet. So some of these areas have still not been, I mean, even a telecommunications company which is performing, say, providing using frequencies, would, one can argue, come under the provisions. So firmly now all public authorities come within this. So, and right to information is now being used very widely. But that also would widen with the definitions here. And it's an important regime, very, very important regime.
Exactly. The essence of the Right to Information Act specifically also states, just as you mentioned, about how there is a liability to make this information public for easy access. How does that liability aspect completely play out? Because we've seen certain abuses of legislature as well. When it comes to very recent events, we've seen fundamental rights petitions being filed in relation to elections. So how exactly does the piece of legislature actually try to prevent some sort of abuse?
Yes. Now, in terms of the Right to Information Act, if we just go a little bit before so that your viewers would have a better understanding. So if it is a public institution, you are a citizen, then you are entitled to request for information. So that is, you make a request to an information officer. So all of these public authorities have a duty in terms of the piece of legislation to name an information officer. You are supposed to have it on your website. So if they are properly following, most of them now follow, you send a request. Then they can either, they can say they will give it or not, and that will come to further in the discussion. So if, for example, if we jump a few steps and say the officer does not, or the institution refuses, or derogates its responsibility, or then you have the Right to Information Commission, which is a robust commission. As we have it, the commission is, it has delivered many orders on the need to provide that information. Because if you go back to the preamble of the Act, it's to provide transparency, accountability. And to me, this piece of legislation is probably equally important to the Anti-Corruption Act. Why I say that is for good reason. The anti-corruption is to prevent corruption, bribery. But the Right to Information Act gives the citizen the right to access that information. And one must also be mindful, and if you're in a public authority, there is no period within which you're limited saying, okay, you can't do it after 2 or 3 years, you can ask for it. So if you do something, if a public authority institution officer does something wrong, say take a tender, they do something wrong and award a tender to the wrong person. Now this is hanging over the head of that person, because at any time, a citizen under the Right to Information Act can seek that information. And the rights arise at that point, and if you have done wrong and if the information is provided, then you can obviously take action. So to me, this is a very important piece of legislation, and it empowers the citizen. If you feel that institution is not doing what, or officer or somebody is not doing what they should, or it should be done better, you can and it's a simple process. It's not a complicated process. You just make a request. There is a form online, or you can even make it in the form of letter. You don't need to provide reasons. You don't need to ask why. You don't need to provide reasons as to why I want the information. You say, I want this information. Could be anyone. And you don't need to show a nexus between why you are asking it and the purpose. So it can be X, Y, or Z can ask for information. And I know there are even NGOs, organizations which are always asking for information, see whether things are in order. So that provides transparency. The transparency must be, everything is open. In terms of this Act, it enlarges scope. And this is something over 100 countries now in the world have adopted Right to Information. So it's enabling the citizen to participate in the operations and functionality of a country. Normally we elect officials from or representatives from time to time. So you elect them 5 years again, but here you can participate.
Exactly. It's almost like a direct leeway into that process in order to ensure that things are truly happening as intended towards the best interest of the Sri Lankan public. Now, so you just mentioned that the process in itself is fairly simple, but we've really not seen as much uptake in relation to the Act from the general public at all. Of course, this might have something to do with the awareness issue, but in a question of curiosity, do you really believe that the accessibility of this Act and also the process towards requiring the necessary information is truly streamlined and simple?
I think now this has been brought in 2016, and we are in 2024. Now this is well known for the reason that most of the cases, even which we do, clients have either already got the information and they know the process. It's a simple process. And even when in our cases, often there is a paucity of information, because you have a case, but you don't have the information. So Right to Information is what we make use of. So there is awareness. Obviously, everything there can be improvement. There may be those who don't know, obviously. But take a simple example. Your child is not admitted to the school. You have grievance. You say, well, no, you can call for information. So you are entitled to get the information. Of course, I must also say that when you say it's not a complete wide right to get, so there are restrictions. Section 5 says certain restrictions when information will not be provided. So as much as there's a right, I said at the beginning, if you look at Section 5 of the Act, it sets out a whole set of situations in which information can be withheld. Now, for example, if it is personal information, so for curiosity, I want to know, the salary of somebody. That will be provided. That's my personal information. But say somebody is getting some salary or some allowance which is wrong. There is something more to it outside the scheme. Then one might be able to argue in the wider public interest demands that information, but not for curiosity. Then if there are issues, if there is an affectation, or it can undermine the defense of Sri Lanka economic activity, something which is being negotiated with a foreign country. But there are other situations where, for example, if it's a professional communication between, say, the Attorney General's Department, and so those information you can't. But now, for example, a cabinet decision, you are entitled to it, but not a draft cabinet decision. It has to take the form of a, it must crystallize. So there are certain now, for example, if it involves, the offence of contempt of court, privileges of parliament, then you can't. But generally, the principle is that if the wider public interest demands or justifies the release of that information must be provided, because one must go conceptually back to the sovereignty of this country is in the people. So we are all part of sovereignty, or we are the sovereign. It's like the king was sovereign, now we are sovereign. But because the fact that 22 or 24 million of us can't rule the country at the same time, we appoint our representatives. So even though we appoint the representatives, they are responsible to us. So it is in that context that now we have been empowered with this right to seek the information, which we are then, and then we can, without having to wait to, if say government is unpopular, then wait till the next election to change. But here you can do it in midstream. That makes it more dynamic.
So basically, there is a legislature provided.
Yes.
It's not that the information is going to be completely available in its completeness at all. There are certain restrictions, but that doesn't mean that the general public have to be completely blinded about certain processes. And we do have a bit of a right to actually know about what's going on in certain processes, and we as a people need to be knowledgeable about that fact as well.
Yes, yes.
I think we do have to speak about the repercussions of not providing information by public authorities as well, and we have to talk about the current context and also some significant cases. But before we get into any of these specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back. Welcome back to Law, Land and Liberty. We're in conversation with Mr. Rajeev Amarasuriya, attorney at law, and we were just embarking on a topic on right to information and the Right to Information Act in Sri Lanka. We just got done speaking about the actual salient features of the legislature. We do have more to discuss as well and break down when it comes to specifics, but we couldn't actually touch on this. We should have ideally touched on this earlier on, because this is exactly what is important, the repercussions aspect of the entire piece of legislature. What exactly is the backlash that public authorities would actually face if denying information from the public? So could you please explain to us how exactly it completely cascades? Is there a genuine reaction that public authorities should be looking out for when it comes to enforcement in this legislature?
Yes, certainly. I mean, of course, we are only now about 8 years into the implementation of the Act, so the repercussions will mature with time. But conceptually, as I said before, there is a fundamental right to information that is enabled through the Right to Information Act in 2016, which says this information which is in the possession, control or custody of a public authority must be released. That is the general principle. Then we have Section 5, which sets out circumstances under which you can withhold information. One is, of course, the privacy element, because that is a competing interest. There are other grounds, as I mentioned before. So if it is information, so if it is not, it does not fall under those restrictions, then the public authority, the information officer, is bound to release that information. Now, having said that, practically also, either there could be a misconception of the law, there could be issues of interpretation of whether it is outside or not, or whether the public of the information officer could just point blank say, well, I'm not giving this information. So ultimately, if it is found that this information should be provided, I would think in a situation of where it is black and white, it should have been provided. If there is some issue of interpretation, the information officer says, well, I didn't think it should be provided. I made that judgment, but maybe it was found to be wrong. But if they don't say a very simple piece of information which is clearly within the ambit, either they don't give the information, they don't respond to our inquiries, Or they say, and the other dangerous thing is they give wrong information. So when you ask for certain things, they tamper with the document and give you something else. Then that officer is liable to be prosecuted before the magistrate's court. The penalty is 50,000 rupees or 2 years of imprisonment. So of course that could take time. But the other repercussion is, of course, when a public officer is brought before a magistrate's court, then you have serious repercussion to the officer, because that officer will not find it difficult to get promotions and other problems. In addition, the institution also can take disciplinary action against that officer concerned. So if I was an information officer appointed in some authority, I would think of that as my responsibility to independently function in that role. And there would be some element of trust and confidence I must in that role and perform it properly. Because if you fail to provide that information under the provisions, it is your responsibility. The Act doesn't say you must need to go and get advice from somebody else. So information officer is to a large extent it's an independent role within that institution, and you have to follow the four corners of the piece of legislation. If you are not providing it, you have to find a reason under Section 5 why you can withhold it. Otherwise, it is your bounden duty in terms of the law and also maybe moral consciousness to provide that information. So there are repercussions. I am not aware whether, as of now, whether any particular office. There are instances where the Right to Information Commission have reprimanded public officers for not releasing. Because what happens is, we must also speak about the appeal process, which is important. So you go to an information officer. The information officer has to, within a period of 2 weeks, inform you whether, 2 weeks or 7 days, inform you whether the information will be given or not. Then you have then either they give the information or they don't. Then you have the opportunity within 2 weeks of that decision of 14 days to appeal to the designated officer. So every public institution has an information officer and a higher level appeal level officer. So usually the practice has been that like the CEO or someone very senior in the organization or the general manager becomes a designated officer. So say the information officer says can't give, you are entitled to appeal within 14 days to the designated officer. If the designated officer can either confirm what has been said, or you can say no, give the information. So if the designated officer says, well, no, I'm not giving this information, then you have opportunity to appeal within 2 months to the Right to Information Commission. So even though you spoke of repercussions, when you go down that process, you reach the Right to Information Commission. So the Right to Information Commission has powers to enforce that the information is provided. And if the information is not provided, they can also go before the magistrate's court. So it is in those circumstances, even if an information officer is being difficult, with the process you will get the information. But if you are dissatisfied with the decision of the Right to Information Commission, then you can appeal to the Court of Appeal. So then it gets to the court system, and then of course from there to the Supreme Court. So of course open and shut cases of information one must provide, but there could be information whether it is coming within the provisions or not. Now I recently appeared in a matter and a judgment from the Court of Appeal, Justice Amarasuriya. So I appeared in that particular instance for the public authority. So I took up a lot of objections saying this information should not be provided. So the Court of Appeal holds it was in respect of a investigation report. They appointed a senior gentleman who went into certain allegations, and it was a preliminary investigation was done and an investigation report. So the Court of Appeal holds in that matter, which is a few months back, that what is included in the preliminary investigation report does not amount to information, because it is still data which has been collected on what is said to be done, which has to be further processed to become information. So they went one step, the court went one step ahead and said, well, no, it was not even information. And therefore, there was no legal duty to provide that. And they held with the position I took up before the Court of Appeal. So it is a process like that. It is a evolving regime, and it's something, especially for a country like Sri Lanka, it is a very vital piece of legislation. It's a vital regime, and it is something which must be given all the resources. In fact, in terms of this act, one of the members, the nominee, is from the Bar Association. So there's a process of appointment. So this is not a traditional agency in that form. So we need to give it. And sometimes when I appear for public authorities before the committee, it is not easy, because you have to defend. I mean, you have to. So, and that is what we need. We need a strong, robust commission, which implements this act in the way it should be, and it's intended to be.
Exactly. And so a question of curiosity in relation to the actual, well, what the legislature caters to, specifically when it comes to public authorities and also the general public or entities that are
Yes.
hoping to seek information from authorities. Do you believe, in your opinion, considering the experience you've had in this field, is it a balanced piece of legislature? Do we see proper equity in relation to the protections and also the restrictions?
Yes, I'm of the view that it is. There is the competing privacy, and then we have the Data Protection Act, which is coming into being, operationalized soon. So there is a interworking between those two pieces of legislation. Because on one hand, if we go back to fundamentals, on one hand, you need to protect the privacy of individuals, and that is a must. But if an individual then breaches the private element of the privacy element and goes into the public domain, and then it's something which is of public interest. And there are a series of judgments on what this public interest, especially overseas. Public interest is not public being interested, not gossip value. Public interest is with that there is an overarching interest of the public towards that activity, but it is either benefiting or affecting the larger public or that community, but there's an effect. So the competing interest is that the two acts have provision which balances the two, because the Right to Information Act specifically says privacy will be protected, and the Data Protection Act, the Data Privacy Act, refers to this, saying this is also right. So to that extent, I believe that this act is good. Whenever I appear before the Commission on behalf of public authority, it's not easy. So you have a lot of information to give. So sometimes public authorities might wonder, so why are we having to give this information? But what we must remember is a public authority is functioning for and on behalf of the public. It is not the head or the GM, or that is not their private property. You're functioning in trust. So you should be able to provide that information. It's not your personal information. Different from a private company. And if you are having a private company, it's my car, my petrol. I'm provided to do it legally. But a public authority, different. So I believe that this act provides for what we need. There is room for further usage of that. I won't say implement, and there's opportunity to use.
We do have to get into the challenges and also the future in relation to this aspect, in relation to the legislature and also right to information in general. But before we go in for a break, sir, I'd like to ask you now, specifically when it comes to the accountability and also the transparency aspect, since this legislature has come into implementation, what have you seen change in the legal landscape? So has it really done its due diligence in actually promoting transparency and accountability when it comes to public authorities?
Yes, I believe that maybe the Act has not directly promoted accountability and transparency directly in the way we say, well, the Act comes in, we must do this. But indirectly it has. And I have seen that happening in the last 3-4 years more than before. Because now public authorities also are conscious that this information which they process, which they have in their possession, control or custody, can at any point of time be demanded by a public. It could be just somebody who's interested. It could be one of your employees who enables the provision. It could be some organization which is focused on transparency. It could be even a busybody. But the Act doesn't say that you need to give a reason. It doesn't restrict the person, provided you're a citizen or even an entity which has 3/4 of membership of being Sri Lankans citizens. So to that extent, I believe that it is something which we must, as I said before and repeatedly, we must enable, protect, and there is no reversing the canvas now. It is there. It's a fundamental. It's a fundamental right, like the freedom of association, the equality, equal protection. This is also a fundamental right now. So to that extent, I believe that this commission, the regime must be provided. It is also in the interest of the public official, because sometimes, I mean, we must be frank, we have problems in our bureaucracy. These are things which you speak on programs. Sometimes you might be pressured by somebody to do this and do that. You can always say, well, I can't do this today, I can't do this, because this is not something, the file is not going to get destroyed. This file is going to be there. So if I do this in this way, somebody who at some point of time asks for this information, it will be released. And then what happens to me? So that is how, when I said it is not directly, indirectly it happens. And I repeat myself, as much as the anti-corruption, the corruption and act is equally or more equally important, this is also enabling that same situation. Always prevention is better than cure. And this should prevent a lot of things happening, because there's consciousness that, well, this information can be.
Exactly. So again, as I would repeat exactly what you have mentioned, just for the viewers to actually understand that truly this act, while it does not completely directly correlate or directly state about accountability and transparency.
It does in the preamble.
In the preamble, yes. But specifically when it comes to its sections as well, there is no need for it to actually always mention accountability and transparency, because by implementing these sections, there is an indirect pressure put on public authorities to actually uphold certain standards, because it's law now, it's legislature, and therefore we must abide by it. So does the public authorities. Again, I just previously mentioned so that we have to speak about the problems that the Act might face and also any obstacles. But before we get into that, unfortunately we've come to time in this segment. Let's take a very short commercial break. You're watching Law, Land and Liberty. Stay tuned, we'll be right back. Welcome back to Law, Land and Liberty. We're in our final segment in discussion with Mr. Rajeev Amarasuriya, attorney at law. So thank you once again for the previous two segments. I believe we covered a lot of ground. Unfortunately, this is our final segment. So I think we should get to one of the most important factors that people really need to understand, and that is the biggest challenges when it comes to the implementation of the legislature and also just acquiring information in its outright. So if you could explain to us, sir, the challenges that the public might face when it comes to handling this piece of legislation.
So the challenge which I see is it's an easy process, but there can be a tendency within certain organizations that, well, we are not going to release this information. Full stop. Though they have to. So by taking that attitude, it just makes it more difficult to obtain the information. So as I said, there is specific ground upon which you can refuse. But sometimes I have seen institutions either ignoring the letter and not responding, or just denying the information, saying for some reason they are not able to provide it. Sometimes that reason is not within the section 5, which sets out the restrictions. So then, of course, the problem the citizen would have is that if the citizen does not have some kind of legal support, the citizen might think the matter ends. Remember the public. So, I mean, we as lawyers, of course, know that we understand all of this. So that may be a challenge one has, because it is easy if a public authority does not want to release, they will first stage will just refuse and see what happens. So if you don't have that assistance, or if you don't understand the provisions, then you might be discouraged to seek that information, and that matter might end. So I think there is a need for awareness, there's a need for those who there is this concept that we are presumed to know the law. So this is not a difficult piece. You can read the provisions. And also I think we need to change the mindset of, I'm not saying everyone, but there are institutions which may not take this very seriously. So of course with repercussions, if you have say an instance like that, and say for example an information officer or a official who restricts information is prosecuted, and there is some awareness of that, this happening might then change. But having said that, I think already this act has achieved much. There is a lot of information which previously was not in the public domain, which has come out voluntarily, and also through the Right to Information Commission and through the Court of Appeal, through the court process. And that has helped, going back to the preamble on transparency and accountability, that has helped even court cases, and that has helped clear matters. And from a proactive point of view, as I said, when you know that you might release this information by law, then you may not get into those transactions or do that act which you might later find that it might be released. Many cases which are filed or litigation or things which are maturing to litigation, the lawyers now advise clients, litigants, well, we can use the Right to Information Commission and seek that information. And that is happening more now than I used to speak on this topic for some time. And initially there was a lack of awareness, but now that awareness is there. It's a very easy process. So the challenge I would think is that certainly the Commission is good. Commission is providing, Commission has a lot of power under the Act. Resources are provided, so the state also supports it. So it's not, there is no allegation you can't point the finger at the state and say, well, you are restricting. This is being enabled. But as I said, maybe awareness, both among the citizen and of course with the public authorities and the information officers. Because if you are an information officer in an organization, you have an independent role. So it is not, then you are not an agent of the institution trying to protect the interests of the institution. You are now tasked with the responsibility as the information officer to operate this act. So you are the agent of this act. You won't be an agent of the institution. That's the difference. So I think that is how we need to progress with this regime, and it's a wonderful, wonderful piece of legislation. In India, there's a lot of progress, and in fact, for many years we were relying on the Indian orders, but now we have a lot of orders from Sri Lanka also, from the Commission especially, which we can rely and make use of.
Exactly. So it was a slow uptake, but
yes.
Now we're seeing it gather steam,
Very
and it's
much so,
actually
yes.
being implemented practically and being put to good use. And now I believe this is the question of the hour, sir. Of course, elections are just around the corner, and we've had a lot of conversation back and forth relating to maybe the duration or candidates, or even among all of that mishmash of information. How exactly does the right to information and this act specifically play into the electoral process?
So it plays into this process like it plays into any other function of the state, whether it's election commission, whether it's some institution. Say some institution is misusing its powers to support a candidate or a party. So you can seek that information under the Right to Information Act. If the election commission is not performing its role, or it's either doing something which is wrong, or it's doing something which maybe should do it in a different way, you are entitled to seek that information. So the provisions are open. It's a tool, both citizens, those who are interested in this, the elections, those who, there are organizations which are trying to promote transparency. It's a tool. But the question is, the tool must be used effectively. Of course, elections, one must also be mindful, it runs in a short time span. So here, of course, it takes a little bit, there are 2 weeks, 3 weeks, so you have to then push and get the information fast. So everything is now in this new world, information is what is important. Information is where the value is. So that information you can get through this. Then what you do with that information thereafter will have to be determined. So it is certainly a very good tool we have. And it will help, again, transparency, accountability, which we all speak of all the time.
Exactly. And when it comes to the future of Sri Lanka's legal landscapes, There is a lot of talk relating to amendments and, of course, changes to existing pieces of legislature. In your opinion, does this piece of legislature require amending? Is there a future change that could be happening?
We will have to see as we go along. I personally, offhand, I think this is, for the moment, it's very, it provides for what we are looking for. There may be a little bit of tinkering here and there which one might find, but it addresses what we need to cover. But this is a new regime for the world as well. So as those developments happen, the definitions are very generic, so it captures now, even if advancements of technology, you might have information, might be something, what we don't traditionally see, but it generally covers. So maybe at some point there might be a need for some rehashing and re-updating what we have, but I believe that we have more time to operate this piece of legislation. It's doing good.
Right. So it's a positive trajectory.
It's a positive
trajectory. We just have to ensure that it stays on track and that we don't...
And make more use of it.
Exactly. We have to utilize this piece of legislation to ensure that it doesn't go into redundancy.
Very much so.
We have to remember...
I don't think this will ever go into redundancy. This is not a piece of legislation like that. But we must make maximum use of this tool which is provided to the citizen. That's bottom line.
Right. Bottom line is we do have to give it a little bit more awareness. Despite it already picking up steam, we need a little bit more inclusion of this act when it comes to our processes as well. And of course, the right to information and upholding that right. Yes. We don't have much time as of yet. I just have a few final questions, sir. One is in relation to the global standards. Do you believe that with the implementation of this act and also the proceeding process that we have seen so far and in current date, are we matching the global mark when it comes to providing that right to information as a fundamental right? Are we doing just as enough as other countries would be? Yes,
I think, we have over 100 countries which are now operating with this regime. Some don't have it as a fundamental right, we have it as a fundamental right. Essentially what our regime is what we're finding in India, and India has been very progressive when it comes to right to information. So I think we are benchmarked. This is a piece of legislation which was talked about for a long period of time. It came during the 2015-19, the Yahapalani government. It is something I think which was also said, which will be brought about. And I think it reaches that, it achieves that, it reaches the level of the benchmark. Of course, anything there is room for improvement. I personally don't see anything really needed to improve on this piece of legislation at this point of time. But going forward, of course, you have one thing which I was looking at, maybe the fines, you say 50,000, you might want to increase it. Because you must also bring in fines, penalties, which are, then you also wonder, well, it's very dangerous, you must not get into that realm. So in my view, penalties should be more than 50,000, because especially now with the changes. But no, I don't think that there is there are other priorities legislation-wise. So let this piece of legislation operate. Let's no need to tinker with it too much. It's doing a good job.
Right. We shouldn't fix what's broken.
You shouldn't. And something's operating, you must allow it to operate and grow.
Right.
Because there is space for this to grow within organically. So let this regime grow, and let it be. We speak of pillars of, democracy. We call media the fourth pillar. But the right to information also can be a pillar or a support.
Exactly.
That provides that.
If utilized accurately,
we can. It is a regime which must be supported wholeheartedly, and it must be something which must be made use of.
Exactly. Well, unfortunately, our time is nearing its end. If you could, sir, just give us a message to our viewers now. We just got into a very packed discussion relating to the right to information, and of course, being the past secretary of the Bar Association, we've seen a lot of contribution on your end as well. As an individual, any future plans in relation to the actual act, or if there's any changes that have to be done, could you please let us in on any processes?
Yeah, I think overall, there are a lot of changes we need. This is something which is new and which is working well. So from the point of our legal system also, I posed a slightly wider question. I think there is a lot of room for development, because we have, in our democracy, we have three pillars. We have the executive, the legislature, and the judiciary, which is the system which we are all part of. And all of those are equally important. One is not more important than the other. And all of those, with like anything, you asked me several times, what is the improvement you need for the Right to Information Act? And I said, well, give it some time. But on the converse, in our legal system, I personally believe that there is a lot of room and space for development. Now take, for example, technology. We speak of technology. I mean, nice to be here in this state-of-the-art studio. But our system has not taken up the technology the way it should have. And I mean, because of my involvements in the law associations overseas, I have the opportunity to visit. And a lot of those countries we have seen have adopted technology to benefit not the lawyers or the judges, but I mean, it does benefit, but mostly the citizens. Because we need to make cases shorter, more expedient, and then of course there will be more litigation. So that is one thing outside, I mean, you asked me a wide question. We need to look at that. We also have to have a robust system which is always supporting the rule of law, ensuring, because it is this third pillar is what has to ensure the check and balance on the other two. So we need obviously to be strong, we have to have, it must be robust, and it must be time sensitive. And that of course, the system therefore, I personally believe technology is the answer to provide, then you don't need to spend too much time on the mundane things. That the technology will provide. And our system, the lawyers, the judges and everyone will have more time to spend on the important matters. So overall, I think like the right to information regime has opened a new window and a space to ensuring accountability, transparency, good governance, which are essentially important. I think also we have to also have, look at our legal system, look at how we can retain what is good, retain the traditions, and of course take it to the future, because we have to look at the future. It's not the present. We look at it for 25, 30 years, bring what is good. A lot of changes overseas, a lot of adoptions, but we have a lot of practices and systems from England, but some of those have now changed. But we are still following what, now for example, I do public law in the writ jurisdiction. We follow a lot of what happened in England, but in England it has changed.
It's changed.
So I'm saying not change for the sake of change, but we need to look out of the box, look at wherever we can improve ourselves, and ultimate beneficiary, it's not for the lawyers or the judges, but the citizen. So that if you have a grievance, if you have a dispute, well, you get into the court system. It is resolved. It won't take extra time, as it sometimes does, because of the workload and of course the resources.
Exactly. Well, unfortunately, sir, our time here has come to a mark. We do have to do a completely separate discussion relating to the efficiency of the legal system as well, and how exactly we need to ensure to advocate towards technological improvements, not just for the sake of improvement, as you just mentioned, but we need change that is actionable and we can actually see it being reflected within the general public. Thank you very much, sir, for taking the time to speak to us here today and enlightening our audience in relation to the Right to Information Act. Thank you, sir.
Thank you very much. Pleasure to be here.
All right, well, the right to information is one that, without any argument, must be upheld always. But more importantly, we as citizens of Sri Lanka must be knowledgeable on how to utilize it in a fitting manner. To realize its significance, we leave you tonight with the words of Swedish Enlightenment thinker and politician Andreas Chenedius. The freedom of a nation cannot be upheld by laws alone, but also by the light of the nation and knowledge of their use. That is all from us here at Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherderana English. Thank you very much for watching and have a good night.